All right, Chris, thanks very much. Well, recently New York passed a law which will allow facilities like hospitals or community health centers to dispense medical marijuana to registered patients. And here to give us a clearer picture of the law itself is Rosemarie Riddell Bogdan of Martin, Harding and Mazzotti. Rosemarie, great to have you with us.
It's great to be here.
How about it? How does a patient qualify to be a part of this program?
Well, in order to qualify to be part of the program, you have to have a serious condition, which is defined actually in the law. It's something like AIDS or epilepsy or cancer or glaucoma or a traumatic brain injury. So that's the first step. Secondly, you have to be a resident of New York or be treated in New York for the condition that they want to prescribe the marijuana. Also, you need to have a physician who is registered with the Department of Health recommending it as being advantageous for you. And then you have to actually get a registry card from the Department of Health and carry it with you at all times that you're in possession of the medical marijuana.
Well, we actually got a question from one of our viewers about this, and here's what they were wondering about: how this new medical marijuana law would affect their employment in terms of, which permit the drug testing, and does they have the right to terminate somebody if they take the test or they fail the test?
Well, that is a very good question that the viewer asked, and essentially you have to look at a combination of different laws. And the first thing I would point out is that the federal law still defines medical marijuana as a Schedule I controlled substance, which is defined as having no legal use. So the federal law does not match New York state law.
What happens then?
Well, what happens is you also have to look at New York. Now, New York has just recently passed this and says that medical marijuana is permissible with the requirements that I already spoke of. So they're sort of in conflict. So then the question becomes, how does that relate to drug-free workplace? Because you have the New York law that says medical marijuana is permissible. Federal law says it isn't. Interestingly, in the New York medical marijuana law, they said that this is not intended to stop an employer from enforcing a drug-free workplace, and that employees can't be under the influence of the drug. So now you have this conflict going on. It'll be interesting to see how New York handles it. New York also has another law that's in the labor law, and it's called the Lawful Activity Statute, which says if you do something outside of work that's lawful, an employer can't terminate you, whether it be smoking a cigarette, drinking alcohol. They're all lawful activities. Now, medical marijuana is lawful. So we're going to have to see how these all interplay.
I was going to ask you, I mean, at some point, they're going to have to resolve some of this, and it's still playing out, right?
Absolutely, and there's a lot of states that have gone before New York, so we'll be able to see how they handle it. And also, it seems as if what the law is allowing is going to say employers, you don't have to have employees that are under the influence of especially deals with safety, making decisions, that type of thing. But generally speaking, there'll probably be some accommodation for the use of medical marijuana outside of workplace hours that allows perhaps somebody to test positive on a screening test for that substance alone, but not be under the influence while in the course of their employment.
It's really interesting, and obviously this is considered by many a first step, so this law could still morph over time, and then it'll be a whole new set of circumstances.
Absolutely. We'll just have to see how it goes.
All right, Rosemarie, thanks so much for your time today and sharing that with us. And if